Terry McMaster, thank you for speaking with us.
It's my pleasure.
I want to talk about your response to the Royal Commission's interim report and some of the substantive matters that both ASIC and the Royal Commission raise in relation to Dover Financial Advisors, your company. But firstly, I want to take you back to that afternoon in Melbourne. And you were undergoing some intense questioning.
Yes.
For those of us who were watching, you became visibly uncomfortable. You know, the colour started to drain from your face and subsequently you collapsed and Kenneth Hayne called in the paramedics. What happened to you?
I fainted. But that's the short story. The longer story, the backstory is a week or so of sleep deprivation, knowing that something was wrong, that the stories coming out of the Royal Commission didn't make sense, particularly the cases of Andrew Smith and Adam Palmer, who were Dover advisors, who were painted as rogues by the Royal Commission, when in fact Dover's experience in the previous 4 years or so they'd each been with Dover, that they were close to the perfect advisors, technically competent, not one complaint, not one foot put wrong in the whole time, and observing a high quality of advice going through when we checked their work. And also intrigued because the nature of complaints is that if there was a complaint from Smith's Westpac days or Palmer's AMP days, in that preceding 4 years, we would have been exposed to it. But there was no such exposure. We did not have the slightest hint that there had been something wrong. And to be frank, I doubt there was anything wrong.
So you talk about the case of these two financial advisors, and you say in your very strongly worded response to Kenneth Hayne's interim report that the evidence, ASIC evidence relating to these two financial advisors was suppressed by the Royal Commission. You also say that you were ambushed. What do you mean by that?
Well, on the day I was ambushed, I was provided with what's called a rubric, a quaint phrase, really just meaning an agenda or a list of things you're going to be asked about. And the rubric was limited to Dover's new advisor recruitment policies and a bit on our statement of advice review and general compliance. I rang the Royal Commission and confirmed that that was the agenda. That's what I would be questioned on. And I relied on that. I prepared for that and didn't prepare for other matters. But on the day, 2/3 of the questions were off the rubric, not on the agenda. Not only were they off the rubric, if you like, ambushes, no notice of the question, but they were spun, they were pitched, not in a way to elicit truth, but to damage, to insult almost.
Surely it's legitimate for the Royal Commission to ask anything that it deems to be in the public interest. I mean, the terms of reference set out in terms of getting to the bottom of misconduct were quite clear.
Well, I'm sure damage and insult was what the public was interested in, but a Royal Commission should be interested in something else. It should be interested in genuinely understanding a process, not in tarring a person who really can't respond. And if that person tries to respond, tries to explain, is either cut off or in some cases literally told, no, you can't explain.
So as a solicitor...
That's not a help.
And as a solicitor, your assessment is that the Royal Commission has lacked procedural fairness on that?
Well, I'll give you an example. I think examples speak louder than my opinion. Adam Palmer, very good advisor. He left the AMP. He wasn't terminated by the AMP. He left voluntarily. He was sometime later accused of misdemeanours by the AMP, and the AMP was brought as the only witness in respect of Adam Palmer. There were a series of leading questions from the leading questioner, and each one of them was, I would say, misleading, culminating in statements that Adam Palmer was engaged in illegal activity and was dishonest. Both completely false statements, to be frank. Procedural fairness, where was Adam that day? When did he get his chance to respond? The ASIC barristers were there. Why didn't they speak up and say something? Mr. Hayne, you've got it wrong when it got to the examination in chief phase at the close of the cross-examination. No one spoke a word.
So this is one of the issues that you've said have been deliberate misstatements from the Royal Commission. The other core issue that the Commission has taken issue with when it comes to Dover, as has ASIC, is your client protection policy. And the charge against Dover is that this policy, these terms and conditions that set out how your advisors interact with their clients, that they were stacked in favour of the licensee, that they were all about shifting liability off the licensee and the financial advisor and putting them back on the client. And indeed, you know, Mark Casello QC described that policy as Orwellian. What was the purpose of the client protection policy? How was it meant to work?
Well, I began to explain that to the Royal Commission, or at least try to explain, and I was cut off, called Orwellian, and the statement was made, not that I was a liar, but that I was speaking untruths. So I was effectively called an Orwellian liar, which became a great headline. Mission accomplished. If I was given the opportunity to explain, to continue, I would have said it's very complex, but in summary, the key feature of the client protection policy was a notice allowed under the law, Section 917D, which doesn't reduce liability, rather it moves liability back to the advisor. Then I would have continued and said that we were telling the advisors at CPD days and induction days and elsewhere that if they don't put the statement of advice in for review, and something goes wrong, we will rely on that notice. So they'll be liable for the negligent act or omission, not Dover. It was a stick to make the advisors put the statements of advice in, which worked very effectively with other tools, with other carrots and with other sticks as well. And that protected clients because it made sure that the advices were always reviewed by our in-house legal people plus an external legal firm, but it also brought into play external legal advice, legal insurance, professional indemnity insurance, which is much better, much better than AFSL insurance in that there's no threshold or deductible amount and there's what's called run-off cover. So even today, the Dover clients are covered by the legal professional indemnity insurance, and that will continue indefinitely.
Nonetheless, Terry, clearly this client protection policy was one of the chief factors that has now resulted in Dover's licence being cancelled. Do you regret that part of your business?
Obviously. It wasn't critical. When it was brought to our attention a month or so before the Royal Commission, 2 years or so after ASIC became aware of it, and after ASIC had reviewed literally hundreds of statements of advice with it in it, without mentioning any concerns, when it was brought to our attention, we actually fixed it within 1 day. We didn't argue. We said, sure, we want to be compliant. If you guys think it's not compliant, we'll change it, and we did. No client was prejudiced. To this day, no clients complained about it. The idea that an AFSL would be shut down in those circumstances is unprecedented. Much worse things have happened recently and in bygone years without anything like ASIC's response here.
So you believe there's a double standard there in the way that Dover was treated compared to other financial services providers?
Absolutely, no question about it.
And just finally, you do talk about in your response to the interim report, you personally having suffered post-traumatic stress disorder, mental ill health as a result of this cross-examination. Do you blame the Royal Commission squarely for that?
A little bit. The Royal Commission was livable, unpleasant, embarrassing, stressful, anxiety-inducing, but it would have passed. The real, I think, evil came later with ASIC shutting Dover down without giving us any choice or option but to shut down and telling us that in writing. And then when we did, as we were ordered to do, on the day we were ordered to do it, ASIC almost immediately came out denying any involvement. That was extremely stressful. It generated very negative press, which is something I've never had to experience before. I mean, I've never been in the press before. That's not what I do. Great stress for my family. And, you know, there's suddenly talk of advisors having class actions and all this sort of thing, and being unable to, at the time, tell what actually happened, having to remain silent in the face of that media and advisor storm.
Well, there are now civil claims that have been brought by ASIC against you. We'll be following that matter very closely. Terry McMaster, thank you for speaking with us today.
Thank you very much. It was a pleasure.